Hello, everybody. Thank you for being here. I'm just going to start up here and then I'll join my panelists very shortly. So, welcome to this discussion and thank you for being here. My name is Emiliya Mychasuk. I'm the climate editor at the Financial Times. When I started in this role, I'm the inaugural climate editor, as it happens, and when I started in this role 4 or so years ago, climate litigation was very much on the agenda. One of the first stories I had to edit, I think, was the Shell decision, which was the Dutch case that made the link between Shell's contribution to climate change and its duty of care under the Dutch law and the human rights legislation. That was not that long ago overturned on appeal in The Hague, and since then Shell has not only revised its business plan, but it's also gone on the attack and sued activist shareholders who are involved in criticism of it. We also had, not very long after, a bit of publicity around the case between a Peruvian farmer and RWE, the German company, with the claim that its activities affected his property and its contribution to climate change and glacial melt as a result was behind that. The flood risk there was not identified, and after a decade, that case was lost recently. We also had, somewhat successfully, the Swiss elder case, so a group of older women, I use the word older advisedly, where they found that the Swiss government had failed to comply on its obligations under the European Commission of Human Rights. But since then, the Swiss Parliament has voted to reject that ruling. And of course, you may have seen recently that glacial melt itself in Switzerland was responsible for a landslide which wiped out a community. So despite the evident outcomes of climate change, the outcomes of litigation are not so evident, and it seems a very long and winding road with little conclusion yet on who will pay, the subject of this discussion. So we see the damage caused by climate change, but the question remains open about whether it's the responsibility of companies that we had here, directors, investors, ultimately perhaps governments, and that means us, of course, the taxpayer. So in the meantime, we have global warming. So that's the scope of our discussion, a very big one today. And I am going to join my panellists now, and I'll introduce them to you as I sit down. And I'll start with one question that they can all give their perspective on, and then we'll have a series of discussions, and then at the end I'll allow for questioning from all of you. So hold your thoughts. So, to my left, far left, I have Sarah Barker, who is just off the plane from Australia, but raring to go for this discussion. She's the Managing Director of Pollination Law, a specialist law firm where she leads the Climate and Sustainability Risk Governance team. And until recently, she served as a non-executive director of one of Australia's largest state pension funds. So she brings that wealth of experience. Next to me, I have Matt Gingell. Only his mum calls him Matthew. He's the General Counsel of Oxygen House Group, which is an impact investment group, and he's a long-time advocate of embedding climate and sustainability into commercial contracts, so looking at right from the get-go. To my right, I have Jasmin Fraser. She's a biodiversity and climate lawyer at the Commonwealth Climate and Law Initiative, where she leads research and commissions legal opinions from international experts on directors' duties concerning climate change and nature loss. And last but not least, Nigel Brook, who's a consultant at Clyde and Company, an international law firm that specialises in insurance, and he co-founded the firm's resilience and climate risk practice. So, my first question will be the same to each of you. Is litigation risk related to climate change just too long dated for companies, investors, anyone to take seriously because it's a problem for the next generation? Can I start with you, Sarah?
So is climate risk too long dated for directors to take into account? That's a hard no. Emiliya, I think for 3 reasons. First of all, climate-related litigation is already here. I'm a corporate lawyer, I'm not an environmental lawyer, and with the evolution of climate change to be a financial risk and opportunity, it's opened up the entire book of commercial law to claims that are catalysed by actions or failures to manage foreseeable climate-related financial risks. So we've got claims under negligence law, tort. We've got claims under contract law. We've got claims under fiduciary duty, directors' duties laws. We've got claims under misleading disclosure and securities fraud laws already. We've already had our first climate litigation-related bankruptcy, which was Pacific Gas and Electric in the US a couple of years ago, where under the weight of claims in relation to negligence and misleading disclosure, a failure to have managed climate-related escalating wildfire risks and their impact on an electricity transmission network, and a misrepresentation of those risks in their annual report. Under the weight of claims following wildfires, the entire company went into Chapter 11 bankruptcy. It's very much here and now, and directors and officers are already taking this into account necessarily. You might, for those of you who were here 2 years ago, when you will have heard Desiree Fixler speak, formerly of DWS, who blew the whistle, so to speak, in relation to allegations that DWS wasn't adequately integrating climate or broader ESG-related risks and opportunities into its investment considerations despite representations to the contrary. Which asset owner or asset manager board did not then turn around and say to their lawyers, are we doing enough? Are we going to be next? It's here and now. It's already happening. So that's the first reason directors and officers need to be thinking about it now, because the risk is already here. The second is because insurers are already taking this into account. And if you think a board is scared of a big nasty corporate lawyer in a grey suit, they're way more scared of their insurers. I won't speak about that too much more though, because Nigel, of course, will speak in great detail with great authority about the way insurance markets are responding to these risks. But the third reason that boards need to take these risks into account now is because of the fact that climate litigation brings forward the materiality horizon of climate-related risk. What do I mean by that? Well, if you think about, say, a physical risk associated with climate change, it tends to compound over time, gets worse and higher over time, even though it might manifest now. So it might only be considered material in 5 years, 10 years, 20 years. But litigation in relation to that risk and to taking action to manage the risk of that risk crystallising can happen now. So you've got cases, for example, like those in the US, where the Conservation Law Foundation brought a claim against ExxonMobil in relation to a future-dated risk associated with its coastal oil refineries not being sufficiently robust in terms of their stormwater infrastructure to manage the future forward-looking risks associated with climate change, storm surge, contamination of groundwater supply, etc., etc. And a result of that litigation, ExxonMobil has had to shut its refinery early. So it pulls forward that horizon in terms of when this is a material risk for companies. So for those 3 reasons, I think, Emiliya, this is something that very much is a here and now issue, certainly not an issue just for the future. Okay, so not just a problem for your directors and officers insurance bill, perhaps, in the short term anyway. Matt, you've been at this for a while. Have you seen any outcomes that company officers, investors need to actually worry about in this generation?
Well, I think to answer the the here and now question, I would say no, because I look at the timescales of climate litigation to date. The Dutch Shell case, which is probably the most well-publicised case in the world, was filed 2,293 days ago. Just to put that into perspective, there were 1,629 days until 2030. So I think it's happening too slowly. The other thing is there were only 50 cases against companies last year. 50 in a global litigation sector. There were 1.73 million civil cases filed in the UK last year, just to put that into perspective. Businesses are not sat there quaking in their boots about climate litigation. Or are they? I think that's the position today. I think they're in a false sense of security because I think the momentum is going to shift out of all recognition in the next decade. I think to get momentum, you need mass and you need speed. And what has happened in the last year with AI is going to change this. You'll be able to find claimants more easily, you'll be able to bring cases more easily, you'll be able to digest and defend things more easily. And so we're going to get this mass participation in climate litigation that is going to make boards have to sit up and look up. The second thing that's going to happen is we're going to start to see brown on brown litigation. So that is supply chains turning on each other where they have obligations to decarbonise in their contracts and they will start blaming each other for missing those targets. Think of a syndicated loan agreement with a net zero cascade target. Who's going to take the blame if that's not achieved? There will be corporate on corporate action within sectors. So brown v brown is going to come. And the third reason this is going to change, and whilst it's not maybe relevant today, tomorrow is going to change, is that we're going to be able to price with very good certainty the climate risk exposure. So we are going to have climate litigation risk adjusted IRRs on investor disclosures. I think those three things are going to shift the next decade where climate litigation is going to fuel decisions, it's going to fuel strategy, it's going to fuel audit disclosures and just become part of the day-to-day business.
That's a scary thought, the pricing of climate risk. We had a story this week actually about catastrophe bonds, which are going through the roof. Unfortunately, they're finding their way from the insurers. So the risk is being offloaded to investors who are investing in these catastrophe bonds. In some cases, another part of the insurance company. But anyway, that's a whole other panel discussion, I dare say. Jasmin, this idea of climate-adjusted risk, the rising extreme weather events, the rising cost of climate change, and how that relates back to directors' duties and whether it's for their children to worry about.
Yeah, so I think that the litigation risk is here now, and that's because the climate risk is here now. Just last week, the ECB, the European Central Bank, noted that over the next 5 years, as a result of extreme weather events, around 5% of the Euro's economic output is going to be at risk. We've all seen in the news the Texas floods, which have resulted in around 18 to 22 billion in flood-related damages, a lot of which isn't covered by insurance. And studies have shown that by 2049, there could be 38 trillion in climate-related damages each year. So the climate risk is here now, and there is increasing amount of litigation against states and also companies. So the most recent Grantham report showed that in 2024, there were 224 cases, new cases, bringing the total amount to nearly 3,000 across 60 different countries. And a lot of these are strategic litigation cases, so they're brought to try and achieve a specific climate action or outcome. So yes, there is evidence to show that climate risk is here and there is litigation risk as well. I want to pick up on your point about whether it's relevant for the next generation of directors and managers, because I think that that's a really interesting point. And I don't think it's been looked at a huge amount in the litigation to date, and that's, can you hold previous directors and managements to account for the decisions that they made whilst they were in office? And that is particularly relevant to one case, which was brought against Emiliya in Poland, which is an energy company. So in 2018, the board signed a board resolution authorising a coal power project. This was challenged the following year by a shareholder on the basis that there was changing EU energy and sustainability policy, increase in carbon prices and increased competition from renewables, which kind of pulled into question whether this was the right decision to authorise this coal power project. The board resolution was overturned and the company had to stop construction, resulting in $160 million US dollars in loss. And interestingly, the Poland Supreme Audit Office took a look at this and recommended that actually there should be accountability for failures in risk management in the company. So the directors, and this is with 87% of shareholders supporting this, brought a claim against the previous directors and management for breaching their duties as a result of failing to undertake appropriate due diligence and not properly accounting for climate risk. So I think that's a really important point to show that you might be a director and manager now, you might not think these risks are relevant to you, but actually your actions, the way that you're accounting for climate risks could come back to bite you in the future.
So Nigel, of course insurance is all about the future. Mm-hmm. How far in the future are insurers actually modelling and how does that present a problem for people now?
Yeah, well it's a mixed bag. So if you go back 4 or 5 years, I think a lot of insurers didn't take climate risk that seriously. There were some very, very notable exceptions. We've had the likes of Zurich, Munich Re, Swiss Re, who've been calling this out for 20 years plus as a real and almost a systemic risk. But there's been a sea change, and there is increasing awareness in the insurance industry that they are at risk. And they're not at risk just for the climate litigation. We'll come back to that. They're also at risk for the physical impacts. That's really hitting balance sheets hard. We had mentioned the recent Texas floods. There was the LA fires in December. Those were very costly for the insurance industry. We're seeing insurers withdrawing from certain zones now. California because of wildfire, Florida because of flood risk and wind, the southern states of America, parts of Australia. And this process is only going to continue, and it's going to put adaptation into the foreground as well, because there's, as insurers withdraw, the risk flops back to individuals, companies, and to local governments. What are they going to do to try to make these risks insurable in the future? If nothing is done, then we're going to see a huge increase, for example, in climate-related foreclosures on mortgages, because you have properties that have lost their value and are uninsurable. So, and uninsurability means uninvestability and no loans either. So the insurance is the canary in the, open quotes, coal mine. The insurers are also starting to put in some exclusions in policies. Climate-related exclusions are beginning to appear in policies. Of course, they're already exposed under a lot of policies, and we're actually seeing some coverage litigation now. There's damages claims in the USA. There's a number of over 40 states and municipalities that are bringing cases against oil majors, saying their emissions have driven climate change, and they are facing the consequences with future adaptation costs. The oil majors will have to pick up the tab for that. Each of these claims is typically worth billions of dollars. They're making their way slowly through the courts. The furthest advanced is one in Hawaii, and one of the targets in that case, Aloha Petroleum, sued their insurer saying, you've got to pay for the defense of this claim. Insurers objected, and there's been some rulings in the last year about that. One ruling is that greenhouse gases are a pollutant, so that if there is a pollution exclusion, that bites. That's a hot issue. That will be fought in other states as well. But some of their policies didn't have these exclusions in them. These are policies written, the ones that were targeted in that case, in the 1980s. And this brings home the point that decisions made and acts taken today can have implications many years later. Just going back to the point here about exposure for directors, this, we had that one very vivid example in Poland. That case is making its way through the courts. There's another one. Sarah mentioned the PG&E case, Pacific Gas and Electric, the world's first climate-related bankruptcy. So that was a company that went under because its electrical equipment hadn't been maintained properly. When they had the high winds, wires clashed together or stanchions fell over, and that started fires. That was documented. And what happened then was insurers who'd paid out to policyholders stepped into their shoes, brought these claims against PG&E, drove them into bankruptcy. What happened next is that one of the claims that had been brought, the bondholders of PG&E had brought a claim against the former directors. In part of the bankruptcy, that claim was given to the victims of the fire. They brought proceedings against the former directors. That claim was settled for $117 million, and that was funded by the directors' insurers. So this is real. It is happening now. And just one final thought on that this point about decisions made today. A board can make a decision, let's take the Polish case. It might be that if you made that decision 5 or 10 years ago, it would be not negligent, based on what was known then. Make that same decision today, on the basis of current policies, current science, what's known and knowable, that may be the other side of the line. It may be negligent. So decisions being made today could lead to people giving evidence in 5 years' time in a court.
Right. So, Nigel's brought up a very interesting case there with PG&E and a couple of others, but that one, if I can ask you, Sarah, to comment on that specifically in context of this unprecedented issue of secondary risks, where you're a utilities company and your equipment fails. So it might not be directly related to emissions or pollution as such, direct contribution to global warming, but a failure in some other way to recognise that your equipment will, in particular circumstances, environmental circumstances, could lead to damage. Is that one of the most significant areas potentially of the current litigations on foot, or is there something more pressing?
Oh, absolutely. I think now that we've pretty much blown past 1.5 degrees of warming, the physical impacts are unavoidable and undeniable, and here and now, even though they will get worse. So happy, isn't it? Who thought corporate lawyers couldn't be happy? But
it's
I think,
Australian.
yeah, I think this feeds into this broader theme, though, Emiliya, of where I think the most important trend in climate litigation is going, which is this whole theme around putting responsibility for the loss at the feet of whom it rightfully lies. No one likes to be left with loss and damage. It's human nature that we look for someone else to bail us out. So I think that Miles Allen, Oxford Institution, Miles Allen said almost 20 years ago now, even the most impassioned environmentalist has nothing on a homeowner facing negative equity. And I think that applies across the entire economy. When people lose money, they look for someone to blame. And in relation to physical damage, that is really where we're seeing this trend around, well, you break it, you pay. If you are responsible, whether through your action or your inaction in failing to maintain your critical infrastructure, you are going to be looked to in relation to the loss. And I think there's two main cases on that are pretty seminal, one old and one new. The old one is a case called Illinois Farmers. So this was a case arising out of Superstorm Sandy, Hurricane Sandy, that hit the east coast of the US in 2012. Getting old now. And as a result of all the storm surge and extreme rain in and around Chicago, Illinois Farmers Insurance had to pay out a lot to both residential and business policyholders for stormwater and sewage infrastructure damage. It then turned around and sued 12 municipalities and water corporations and said, well, you caused our loss. You caused the fact that we had to pay out under these insurance policies because you knew or ought to have known that this municipal infrastructure that you built in the 60s was no longer fit for purpose based on the extreme weather that we can now expect in Chicago. Now, interestingly, this claim was withdrawn after 3 weeks. Illinois Farmers is owned by Zurich. Zurich was actually insuring the municipalities that it was suing. And everyone thinks, well, who gave that to the graduate to run? But this is why it's actually so important. Strategically, this was one of the largest insurers in the world saying, we are a business. We have shareholders and stakeholders to whom we are responsible. Infrastructure owners, don't sit back and think that insurance is going to dig you out of this hole, because we are going to seek to put the blame at the foot of whom it lies. And there's a more recent example that I think Nigel's going to talk about later on. But then the more recent case that I think is really significant is that Peruvian farmer's case that you mentioned, Emiliya. Now, I have to pronounce his name phonetically, and even then I think I'm doing it wrong. Nigel, can you pronounce his name for me? Yuya. Mr. Yuya, the Peruvian farmer, as I'm sure all of you saw, was suing in Germany, RWE, for a percentage of the cost of updating the infrastructure around his farm to protect it from glacial melt. So his farm was below a glacier, and as a result of climate change melting the glacier and causing more extreme rain in his area in Peru, he was seeking 0.47 of the cost of having to build resilience protection, stormwater barriers for his farm, seeking that from RWE in proportion to its contribution to emissions since the industrialisation of the global economy. Now, the headline is he lost. The headline is the German court found under the German Civil Code that the risk to him didn't reach the threshold of impairment to his property under the German Civil Code, which they found that there was only about a 1% chance that his property would be damaged in this way. And that wasn't enough to enliven the immediacy, essentially, of the loss that was needed under the German Civil Code. But this is such an important case, a case that cannot be appealed in its findings because of 5 conclusions that the court reached, arguing against every single argument that carbon majors usually raise when they're arguing why they should not be liable to pay for climate damages. So I'll take you through these 5, and apologies if I have to read some because I literally rolled off the plane at 6:30 this morning. So the first thing that the court found against was the argument that because climate change is a global problem, there is no legal basis for the liability of an individual for its consequences. So no, it doesn't hold. Second thing they said that doesn't hold. Climate change is a matter for government and policy, and solutions to climate change can only be implemented at the state and political level. Nope. Court said basically that was a bare and transparent attempt by a large emitter to avoid having to engage in proper legal argument about its liability. The third argument they dismissed was the fact that RWE's activities relating to coal-fired power were not only legal, but they were regulated. They were subject to greenhouse gas offset requirements under the German law. And not only that, they served a very big public good. Public interest in Germans for having energy. The court said that is not an excuse. Just because you have a legal licence to operate doesn't give you carte blanche to operate illegally in every other area of your operations. Does it mean that because you have a licence to generate electricity, that you're allowed to ignore planning laws, that you're allowed to ignore occupational health and safety laws? Hell no. So it doesn't give you a licence to otherwise breach the property rights of third parties. Fourth argument. There is no causal link between localised emissions and climate harms occurring in a different jurisdiction. Ba-bow. Again, court said no, don't accept that. They rejected the argument that it was too remote, the link between emissions that were then indistinguishably mixed and amplified with feedback effects and blah, 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 so that there was no linear causation between the source of the emissions and the impact on Mr. Uya's farm. I basically said here, we're not dealing with scientific causation, we're dealing with legal causation. And it is undeniable that there is a direct link between the emissions and the outcome of increasing that risk of flooding. It wasn't random, it wasn't improbable. In fact, it was inevitable that because of these significant emissions that it would result in an increase in warming and therefore an increase in risk. The court there accepted that every degree of warming matters, and that a large emitter like RWE should have known about the risks associated with emissions to climate change, to warming, to physical damage as early as the 60s. And then the last argument that the court threw out was basically that RWE was too small, that its contribution to global warming was immaterial. And how can you blame us when we're responsible for 0.47% of industrial emissions? And the court said, with a multi-causal problem like climate change, we need to look at relative contribution in a context where even the largest emitter in the world, Saudi Aramco, is only responsible for 3.6% of the globe's emissions. RWE is a carbon major. It's responsible for a significant proportion when we look at it like that. Sure, there's got to be a materiality threshold. It's not like a person in the street or a local store who's responsible for lots of zeros after the decimal point are going to be responsible. But in this context, essentially anyone on the carbon majors list, Richard Heady's carbon majors list, is going to be, under the German law, considered to be sufficiently responsible for climate change to be proportionately responsible for the damages that are caused. So if you're thinking about that in the context of potential consequence of litigation, I think those two cases, Illinois farmers on infrastructure and adaptation, and RWE on who is going to pay, really the only two cases you need to know about.
Okay. Chill in the room. I'm particularly interested in that conclusion about the link between climate change and emissions. So there seems to be no discussion in the courts at the moment that there is no such thing as climate change or that emissions are rising or any challenge to the science, despite the polarisation kind of notion. Matt, you brought up pricing and pricing risk and managing risk. What are some of the things that can be done to manage risk now?
See, this is what happens when you don't turn up to the briefing for this panel, is you get the most ridiculously hard question that can possibly be about pricing.
Other panellists are going to help.
So, yeah, okay. Yeah. But it's interesting, those arguments that were run, actually, because it sounds a bit like my kids when they've broken something and they just try and blame each other and find every single excuse they can possibly throw at it, whereas actually in reality they're both to blame. So I always link it to my kids because I think it's that generation that are going to be most effective. So I think you've always got to remember, whilst we're talking about these cases, that we don't become disconnected with what it actually means for the future. So that it's not an academic nice to have. We're very privileged to be here. So that's why I always connect it to my kids, because I'm allowed to do that. Pricing is really difficult, and And I think if it was easy, we'd all do it. But as you heard there, that it's multi-jurisdictional, multi-vector, multi-actor, multi-disciplinary. And so that makes it a really complex issue to try and price into the market and to adjust your investment returns or your balance sheets or to make a reserve for that when you are going through an audit process. So it is possible, though, I think. And because we now have some very clear attribution science, which is linking to attributing legal blame, we can connect the dots. But we need scenario libraries, we need probability models, we need severity models. And I heard earlier that Equinor, as a result of the Trump administration, were losing $50 million a week on a project. Well, imagine what climate litigation is going to do to delays. It's going to make that a real risk for any project that you are investing in. So it's got to be a known risk before we invest in anything, and pricing that risk is something that investment professionals have done for all time in terms of credit risk, in terms of market risk. So pricing climate litigation risk is the next step, and as I said earlier, I think we'll see IRRs adjusted for climate litigation risk in the future.
Because so far, the discussion which was had previously was how much do you price carbon per tonne, and how do you cost carbon capture, all those sorts of things, adaptation and mitigation risk rather than damages risk.
Yeah, and the damages risk is really unusual because in a normal litigation scenario, you say, well, what are the likely damages we're going to win, and what's the probability of success? You times those two and take off the legal costs, so you basically end up with nothing. But that's how you calculate it. Now here, most of the climate litigation is often not financial. It's an injunction, or it's to go and take account of this in your planning submissions. So it's not actually easy to calculate because it will be about delays, it will be about how much additional interest you have to pay on that project. And so it is really, really difficult to calculate, but I think what it will show is, I created a model when I was asked the question, and you can get back to how much per tonne this is costing. So climate litigation, if you price it, can create a shadow carbon price. And then you need to see whether that shadow carbon price is equivalent to your internal carbon budget price, because I suspect it's very different.
For those who have an internal carbon budget price, yes. Jasmin, so there actually are some laws where, the climate change is borderless, of course, global warming is borderless. Each country has very distinct laws, and in this one there are various fiduciary duties and so on. I think somebody was citing Section 172 duties to me, 174 duty to promote company success. How can they be enforced and impressed upon directors when you're talking to them about their fiduciary duty in respect to climate change?
Yeah, so just taking a step back for those who aren't aware, so under companies or securities law around the world, directors owe a number of duties to their company. Two of those duties include the duty to promote the success of the company for the benefit of the members, and the second is the duty to act with reasonable care, skill, and diligence. So those duties, they do evolve over the time. Just because they're laid out in the law, that doesn't mean they're static. And that's because the law commonly assesses the duties of care, skill and diligence, and to promote the success of the company to the regulatory, social, and market context that the directors and the companies are operating in. And that may raise over time. So, as was said by Nigel earlier, a reasonable decision of a director 50 years ago might not be considered reasonable today. And specifically looking at the duty to promote the success of the company, in the UK, when fulfilling this duty, directors must have regard to a series of non-exhaustive factors. And one of those factors includes the environment. And there have been a number of legal opinions now in the UK, Australia, the Philippines, Singapore, Malaysia, India, by senior corporate lawyers who have clarified that the duties to promote the success of the company and the duty to act with care requires directors to be considering climate but also nature risks, and failing to do so could result in them breaching their duties. So this was also very much confirmed in the case against Shell. So Shell's a case was brought by minority shareholder Client Earth against Shell's board of directors.
So that's a separate, just to be clear, it's a separate case to the Dutch case.
Yes, separate case to the Dutch case we were referring to earlier. So this was directly in relation to Shell's and the board of directors' management of climate risk. So going back to your question about how can directors be convinced that they have to be considering climate risk, well, firstly, because the law, these legal opinions are pointing to the fact that it does, but also in this judgment, whilst it was dismissed, that has itself been criticised, the judge did confirm that directors do have a duty to be considering climate risk. So that's pretty significant. Whether directors actually realise that they have these duties, I guess if you're working in a company, then that's a question to be asking your board. But the Shell case definitely put directors on notice that they need to be thinking about climate risks. I think that there is probably a need to be training and upskilling directors so that they're aware of how climate is impacting their businesses, because if you're not aware of the risks, it's going to be very difficult for you to prove that you're acting in accordance with your duties.
And are you seeing a change in boardroom structures to reflect these changing sort of risk parameters? You know, some companies have a CSO on the board, some people do not, some people have it reporting into the finance function, some people have it reporting into the compliance and risk function. How do you see that evolving?
So I think that obviously it's going to change for every single company, and it might change depending on the sector that you're operating in. You mentioned chief sustainability officers. We might have some of them in the room here. I think the first CSO was appointed back about 20 years ago by DuPont, which was the first US publicly listed company to do so. And now the number of CSOs being appointed has increased. So I think that in 2017, there was about 19% of S&P 500 companies which had a CSO, and that rose to 27% in 2022. Previously, the CSO role may have been seen as more of a kind of PR role to tell a story about the company's sustainability initiatives and to manage risk reputationally when things might go wrong. But I would like to think that now it's, the sustainability officers and sustainability teams are working increasingly with operations and risk and finance teams and becoming more integrated within, determining the company's strategy. I know that Joanna I was speaking about IKEA. I read somewhere that IKEA, for each country group, their CEO is also their CSO. And it seems to be working for them because they've managed to decouple their emissions footprint with their revenue. One other change is also the kind of rise of sustainability committees. They're not necessarily a legal requirement, so you don't have to have one. I think they can be useful in demonstrating to investors that you're taking these issues seriously and that there is somebody and a team with relevant expertise in the company that's thinking about these issues. But you need to have relevant governance structures in place to make sure that those risks that are being identified by the sustainability committees are actually getting up to the board. So as a director, you can delegate certain tasks, engage experts. You very much should be doing that, especially when you don't have the relevant expertise yourself on particular issues. But you can't delegate your duties themselves. So you might be having a sustainability committee who's looking at how exposed your company is to climate risks and nature risks, might be thinking about assisting with disclosures. But you as a board have to make sure that if you have a committee, you have sufficient oversight of them. The other way to do it is not having a sustainability committee, but actually kind of integrating sustainability terms into the terms of reference of the audit committee, the risk committee, the remuneration committee, to just make sure you're taking a more holistic approach to these issues.
It'd be interesting to see what best practice emerges, because I've just seen with the banks, for example, they've shifted roles. HSBC had a board position for its CSO, it now no longer does. So this is, of course, still yet to play out. Nigel, other than directors and officers of insurance going up, I guess, in this category, what are the other consequences as assets become uninsurable?
Just broadening out the exposure, so directors and officers, obviously in the firing line, we've seen those two high-profile cases. There will be more. general liability policies are exposed. So you've got the cases in the states I mentioned, brought by municipalities and states against all majors. Insurance is implicated, there will be coverage disputes, but the general liability policies would be the target for the oil majors there. And something we haven't mentioned, just mentioned in passing, is greenwashing and climate washing cases. Those could trigger general liability policies as well. So those are, they're not as systemic, shall we say, in the risk they pose to the defendants and to the insurers, but they're worth mentioning. The broader context of insurance and the role it plays here, it's a twofold role. Of course, the only way to stop this problem, ultimately, or stop it getting much, much worse, is to cut emissions, and that's where you want insurers to lean in. And there has been a lot of that. There are initiatives underway, though some of those have come under attack. So the Net Zero Insurers Alliance, for example, has shrunk dramatically over the last year because of attacks from...
Doesn't exist anymore, does it?
It's
Defunct.
And efforts to collaborate publicly are now pretty much dead. Right. But there is still scope there for collaboration in a quieter way. And so that's one side of the equation for insurers to find ways to encourage mitigation. And I suspect that will be... The insurers who were members of this, I think most of them still maintain their ambition in that regard. Some have already declared that if there are companies they currently insure who don't have a meaningful transition plan, then they will, if they can't persuade them to change, then they will simply walk away. And I think we may see that happening increasingly. So that's one side of the equation. In the shorter term, it's adaptation. And there is actually, again, a case here. Sarah mentioned that case arising out of Superstorm Sandy in Chicago, which had a lifespan of a mayfly 2 weeks before it was withdrawn. That looks like the definitive own goal. But there is a new one in South Africa. It was filed at the end of March. There was a major flood in 2022, and this caused immense damage to Toyota's local factory. Insurers led by Tokyo Marine paid out on that, and now they're bringing a case against 3 municipal bodies saying you should have taken steps to improve drainage and avert the risk for us and other operations in the area. It's your failure to do that that gave rise to our loss. You are going to compensate us. And that's a claim for £270 million. And I suspect we will see this happen more. I think they may have done their homework this time and worked out whether or not these bodies have insurance in the commercial market, because that's one inhibitor so far. Will this just be cannibalism, essentially, one set of insurance against another? But I think there's a message coming out from this that insurers want to work, if they'd like to work with insureds, to encourage them to take steps to minimize their risk, but also with municipalities and local governments. And some things are happening. So, for example, in Florida, modern hotels, if you go, I haven't been to holiday in Florida for a long, long, long time, but there is virtually nothing at ground level. There's the entrance. Everything else is up on the first floor and above. Swimming pool, everything else. They're designed such that if there is a storm surge, the water can flow through and the hotel is left intact. We're going to see corporates doing this similarly with their own operations. Those who have deep enough pockets can take these steps. Those who don't, and including a lot of homeowners, will be forced to turn to municipalities and so on and say, what can you do to protect us in terms of physical infrastructure, but also prospectively in terms of planning and public policy. This is going to come, I think, into increasingly sharp focus, and where it's perceived that not enough has been done, I think we will see insurers and others stepping in and suing.
That Tokyo Marine case, as you say, is very interesting because it is a professional taking the case, an insurance company, as opposed to some of the activist-driven cases that we've referred to, by and large, as being the most prominent. And you also touched on, these alliances, industry alliances, which have fallen apart, the Insurance Industry Alliance and so on, and asset managers is also all but crumbling. And this brings us to America, the land of suit and countersuit. And, we're seeing now quite a lot of action there where, in fact, some of the oil and gas companies are fighting back. ExxonMobil suing activist shareholders, and the tables are turning in places. And I wanted to sort of go across our panel and talk a little bit about that and how you see that playing out. Is it something that you think, it's only going to be the next, whatever it is, 3.5 years till the next election, and laws could shift again? You have suits against asset managers, which is the reason for these alliances falling apart, claiming collusion by red states in America. So you've got this whole other litigation ball game, if you like, going on. Sarah?
Before I started specialising in sustainability, I was an antitrust lawyer, competition lawyer. You will not find an antitrust lawyer globally that thinks that claim has any merit. It's wholly political. Doesn't mean that it hasn't had a chilling effect on collaboration around the world, but it certainly has significant doubts as to whether or not it has any legal merit. Putting that to one side. The world is broader than America. And when we're talking about litigation trends around you break it, you pay, globally we're seeing claims on this theme. Basically, we're seeing kind of the soft belly being poked, different causes of action in different jurisdictions around the world until something sticks well. So in Europe, they're more duties-based. In jurisdictions like Australia and New Zealand, they're more based in misleading disclosure or negligence, tort. In the US, and we should remember actually 60% of US GDP is controlled by democratic states. Linking back to the theme that Nigel raised around municipalities and who is going to pay, municipalities are faced with these adaptation bills of tens of scores of billions of dollars that they can't pay. They mostly self-insure, they can't get reinsurance. So what are they doing? They're introducing super fund legislation. And not super funds as in pension funds, which is the way that Australians refer to pension funds, but based on the super fund environmental legislation that was first introduced in the US in the early 80s, which is essentially meant to be a look back to companies who had previously controlled land that was then polluted. So if the most recent polluter went bankrupt, for example, that there would be someone to whom the municipality could turn to require to remediate the land. So what this super fund legislation does is basically look backwards to the last 20 years and say, okay, who has been responsible for emissions over the last 20 years? Proportionately, we will seek to levy a fee on those large emitters in proportion to the cost of adaptation. So New York, for example, is seeking $75 billion from the carbon majors to assist funding the stormwater updates that it needs to make even under a 1.5 degree scenario. So there's that litigation pro and con in relation to that legislation, because you can imagine the American Petroleum Association isn't so happy about that legislation going on. So all around the world, there's different causes of action. Poking that soft belly, something will stick. And it's a bit like that adage that everything goes really slowly until it doesn't. When it hits that critical inflection point, and it's all going to snowball.
So there could be one case that triggers
Absolutely.
a whole lot of other consequences. Matt, what about the role of investors? We see now, I see a sort of divergence between pension funds that are looking at payout dates for retirees that are decades ahead. So they are a little bit more concerned about corporate activity that has a link to climate change, whereas more short-dated investors not so much. How do you see it playing out with impact investing?
I don't think it's going to change because what we're seeing is a lot of money coming out of the States and going into impact in the wider world, which I think is probably a good thing. I always think of it as a pendulum, and the pendulum is swinging back at the moment, but we're getting ready for when the pendulum turns, and I think a lot of people are doing lots of good projects, collaborating under the radar, so to speak, and carrying on as normal. So I think that the people that were already doing the right thing are continuing to do the right thing. And I think those opportunities will come to the fore and be talked about more and shared as case studies, and that will create a momentum of its own. But the thing as lawyers is that professional standards cut through politics and legislation. So no matter what I do as a lawyer, no matter what jurisdiction I'm in, I have a duty of care to advise my clients on the risk. And so when you realise there's tools like this, you can talk a different language about, well, it's not about the politics of the day, it's about duty of care to the client. So duty of care to the investors is to manage the risks. And so when you connect all those things and talk in that different narrative, it becomes really powerful. And when you can price it, it becomes real to the board because they have to consider it for their financial statements, their balance sheets, their investor disclosures. So this is how it's all connected. So I think climate litigation is really important in terms of actually translating real risk into the board.
Jasmin, are you seeing pension fund trustees increasingly seeking advice?
I can't say I actually engage with pension fund trustees that much, so I might have to give that one a skip.
That's a next opportunity. We're getting close to time, so I wanted to give an opportunity for people who are in the audience to ask questions. We have lots of subjects to go on with, but I can see scramble for the microphone. And for those of you who've been storing up questions that I have not asked, you've got one, have you, Matt? Okay.
I've got a question for the audience. Has anybody who's appointed a non-exec director on a board, has the non-exec director asked about what our climate litigation exposure might be as part of their due diligence and onboarding? No.
Why would they volunteer that?
Well, no, they don't know. Just interested, because I think we're going to start to see these questions be asked by non-exec directors, because that's part of the role, before they join boards.
You can talk to Matt privately afterwards, if you are in that case. Now, where has the microphone, and who have I got with a hand up, please? I can see one there. Blue, something with the blue, I can see a blue arm. Oh, either. I take it in turns.
Hiya. Thanks very much to the panel. I'm Alex Lombos from Client Earth. I wonder if the panel had anything to say about Green vs Brown litigation and trends there, maybe commenting on Iberdrola and Repsol in Spain, which was a case where Iberdrola sued Repsol on the basis of anti-competitive practices for misleading around its energy business. So that was my question.
I think that's the Iberdrola suit that's in France. Is that the one? Spain, sorry. Any thoughts?
Was that the one you mentioned?
Sorry, say
No.
Iberdrola suit.
So that's the case where it's company versus company greenwashing case, yeah. So this is an interesting case where Iberdrola, very large energy company, big in renewables, is suing Repsol, who's another large energy-based company, for essentially greenwashing in relation to overstatement of its the proportion of its business that's renewables versus conventional oil and gas. It's a really significant case because for the first time we've actually seen a competitor call BS, basically, rather than an activist or a regulator from a greenwashing point of view. So it's a really significant claim.
So far we've had a lot of Advertising Standards Authority rulings about greenwashing, mainly brought by activist groups, so one to watch there. And then the other question, which was in front of you, I think.
So, hi, I'm Rafael. I'm a student from the University of Sussex, and I also come from Colombia and had just 2 quick questions. So the first one is, I feel that the conversation focused a lot on climate change, in climate litigation, and I was wondering if you could expand how firms and insurers are accounting for biodiversity loss and soil degradation as a litigation risk. So that was the first one. And the other one is, indeed, like the world is bigger than the United States and how can we level the play field for global south producers, mostly smallholder farmers, which don't have access to these fancy law firms to make those claims and to actually play the game in getting, not in the sense of loss and damages, but getting their fair share of financing that they need to adapt and continue to basically produce the food of the world.
Yeah, so I'll get onto the Global South issue because that relates to something we were talking about to do with philanthropically funded activity. But ahead of that, the question, of course, about biodiversity and nature. Nigel, do you want to take that one?
Yeah, we are seeing an increase. We put out a report on this 2 or 3 years ago. One big difference between climate and biodiversity is standing, legal standing. So with climate cases, there's various ways you can establish that you have a basis for this entity, this person is entitled to bring this claim. And it's a big, big issue. Some of these climate cases have been struck out for exactly that they haven't got the right standing. But if your own property is at risk, for example, if you're going to be affected by climate change, then in principle you could have standing, depending on the rules. With nature and biodiversity, if it's not your nature, your biodiversity, your bees or whatever, that's an intrinsic limitation on the class of people who can bring a claim. We are beginning to see some countries giving legal rights to natural resources. There's a few countries around the world that have done that, and they have, in fact, then gone on to make successful claims. But without that standing, it's difficult. In principle, there are actually environmental insurance policies. They could be exposed. But again, it would have to be because the entity they're insuring is itself exposed to claims. It could be a breach of regulation, for example, which forces them to pay damages, in which case, fine, there's standing is easy, and insurance would pay out for that. But in the broader scheme of things, this is at the moment an impediment on claims.
Emiliya, can I?
Yeah, please.
I think if you look back, there's a publication that we put out in 2021 called The Gathering Storm, which was about how the climate litigation playbook applies to biodiversity and nature that Commonwealth Climate and Law Initiative put out. But I think the biggest area we're seeing here is in relation to greenwashing. It's exactly the same, where you've got representations made by companies about their commitment to the environment, as well as climate change, and what we call the say-do gap. You're saying this stuff, but when you look at what's going on in the ground, is much really happening. So in Australia, and I should say Australia is a silver medalist, woohoo, when it comes to climate litigation behind the US, we have facilities under our Corporations Act and our Superannuation Act that allow either pension fund members or shareholders to bring essentially books and records claims against companies. And those have been used frequently, particularly against banks, to elicit information from banks about, well, you say that you're concerned about deforestation and you're examining it in your portfolios. Show us what you're doing. And actually here, David, can you give a bit of a wave? David Barnden, sitting there, give another wave in case people missed, who's a principal of Equity Generation Lawyers. He's been instrumental in bringing many of these cases in Australia. So if you want some real life examples, bail David up at lunchtime.
Yes, please, Jasmin.
And just another one on we've spoken about the greenwashing. The principles are very same for climate and also for nature, but obviously with nature and biodiversity loss, it's much easier to prove, that a tree has been cut down and it's caused so-and-so a harm. And I think that especially with increasing supply chain traceability, it's much easier to tie the damage to the harm that's been caused. And I think that people are starting to look in more strategic ways about how to start bringing claims in relation to nature. So one that comes to mind is starting to use money laundering claims. So environmental crime was added under the EU as a form of money laundering, and the UK follows a similar basis. So there's been a recent case in the UK, a claim against or a complaint made against the London Metal Exchange in relation to allowing trading of commodities which were linked to environmental harms and also the harming Indigenous communities. And had those activities taken place in the UK, they would have been illegal, and therefore that triggers liability for the exchange. And then also a case in France by a group of banks, against a group of banks, by NGOs, BNPP and others, for financing Brazilian meat companies, and that being tied to deforestation, and deforestation being illegal both in France and Brazil. So there's lots of interesting ways that cases can be brought in relation to nature.
And it may be that the breakthrough will come in litigation on a nature-related claim.
My first degree is marine science, so I think there's going to be a whole load of ocean cases, and there's all sorts of hidden depths of legislation around harbour masters required to protect the environment, and that includes nature. And there's all these hidden bits of legislation that haven't been uncovered yet, which are going to give standing for nature claims. And the other thing, I live in Devon, and there's a big class action going on in a little town called Exmouth, where about 1,000 residents and businesses are suing South West Water for loss of amenity and loss of business as a result of polluting the water. So that is a nature-related and will have a positive impact on biodiversity as a consequence of bringing that claim. So I think it's secondary outcomes.
Also interesting as carbon credit markets develop, where pricing is made of things like rainforest projects, or also private equity is starting to buy into different regenerative soil projects which involve farming, where there's damages there, then they could also become professional litigants. And on the Global South, not that we can solve all the problems of the world on this panel, but we were discussing earlier about the role of philanthropically funded lawsuits, but also, in fact, Sarah, I think we've had this week the Torres Strait Islanders case where they sued the Australian government unsuccessful about its
Not that Australia is a Global South, but yeah.
Policy, yes.
Geographically, maybe.
Yes.
But yes, I think the role of global philanthropics can't be discounted in terms of strategic litigation, and the Luya case against RWE, for example, Global South. There's another claim on foot, similar claim where Indonesian fisher people are suing cement giant Holcim in Switzerland. So I think there is a lot of opportunity, particularly on the climate front, for extraterritorial litigation because of the very fact that localised emissions go up and are intermingled and create climate change and then have effects elsewhere. So I think there is significant opportunity for litigants in the Global South to be bringing claims in jurisdictions in the Global North as a result of climate change. And don't talk about the Pabai case because I might cry.
That particular case didn't succeed, but a future one might. We're closing in on time, so I just wanted to ask all of you to end on a summary and action-oriented note, as I call it. I don't know if it's going to be a call to arms or a single piece of advice that you would have.
Oh, you're looking at me,
Yes,
sorry.
yes.
I'd hark back to a comment that Matt made about risk. Too often I get asked by General Counsel, Chief Legal Officers in very large corporations, tell me what our legal obligations in relation to climate change and nature are and we'll follow it. It's a wrong question. Climate change and nature are not compliance-related legal issues. They are risk-related issues, looking forward, what is likely, what is foreseeable, what is reasonable in terms of conduct. So the one thing I would do is to ensure that your General Counsel is asking the right question in terms of what, on a forward-looking basis, are the areas of novel climate-related liability to which we are exposed and whom has advised us on that? Because there aren't many corporate lawyers in the world that understand this stuff.
The first session had a call to arms on radical collaboration, and I would like to collaborate with anybody here to create a climate litigation risk pricing model, because I think if we have that, it translates for the GC what this actually means to the business, and that will become really, really powerful.
Because at the moment we have these sort of big trillion-dollar figures, percentage of GDP, stick your thumb in the air. That would be a very useful thing to do. Jasmin.
We've spoken a lot about risk. How do you go about managing risk? Well, for directors in particular, a legal opinion was published in 2023, specifically on directors' duties in relation to nature risk. But that very helpfully outlined 5 steps that directors can take to try and minimise allegations that they've breached their duty. And whilst it was specifically in relation to nature, I don't see any reason why it can't be applied to any other risks that a company is facing, be it climate and other sustainability matters. So first of all, make sure you're identifying the risks. It's going to be very hard to prove that you've not breached your duties if you've not identified the risks at all. Ignoring risks is not going to be a competitive advantage. It's going to open you up and it's going to be a vulnerability. Number 2, assess and evaluate those risks, which are material. For nature, TNFD assessments will be useful there. Mitigate and manage those risks, so decide in good faith the best course of action to take. Disclose, you might have to do that under mandatory frameworks, but if not, think about doing it voluntarily. And finally, document the process that you've taken. Having an evidence trail is going to be very useful if anyone starts pointing at your door and saying that you've breached your duties.
So you can say, look, I did ask in that meeting about the planet. Nigel, who will pay? What
a big question. Well, it touches on 2 points I wanted to make first. I'm being greedy, 2 rather than 1. First of all, if you feel that your board is perhaps not up to speed on climate generally, then think about appointing NEDs who have been trained up on climate, and I refer you to Chapter 0, who have done great work in that area. Are there any Chapter 0 NEDs here? No. Oh, well. They've done fantastic work here and in a lot of other countries, training them up, and that would instantly strap on a lot of expertise.
That's the Directors Network.
Yeah.
Yeah.
And then secondly, I would say forward-looking. It is risk-based, but it has to be forward-looking in the stronger sense that when you think of a GC, we lawyers are trained to look at precedents and existing laws and principles. They're out of the window, really, when we're facing a rapidly changing physical and transition risk for climate and rapid degradation in nature and biodiversity, and we're finding out more every day. What's happening to the climate now shouldn't be happening. The models are missing something, for example. This is a rapidly changing space. You have to look forwards. The rear view mirrors are really no use to you here. It's absolutely through the windscreen. And then, will insurers pay? Well, again, dialogue with insurers. I think with a company that is taking all of this very seriously, that really has got to grips with its own operations, with its supply chains, has identified climate risk in a rigorous way, will be although it may look like they're at a disadvantage because they'll be saying things to insurers that some of their peers are not saying, I think it'll rapidly become clear they're the ones who will still be insured in a few years' time.
So the pace of climate change, which is undeniably accelerating, may be the thing that pushes the legal system along, as well as, of course, policymakers, I dare say. But in the meantime, legal advice, price the damages, the risk, the costs, and also the opportunities, I imagine, for those who do pay attention, and disclose and inform yourselves as much as possible. It's always the key is information. I would say that as a journalist, but there you are. Thank you very much. I don't want to hold you between, we're standing between you and lunch, so thank you very much, and please come and talk to us afterwards.
Great plenary sessions to get us going. Two really important cross-cutting topics to lay the foundations for our future discussions. So lunch is served, it's through there. We're going to be reconvening at 2:30. The session here is going to be chaired by Sophie Robinson-Tillett on EU regulation, all that stuff. And then we've got a session on AI and its application in sustainable finance in the e-schools over there. So see you at 2:30. Thanks, guys.